Good morning, everyone. My name's Andrew Singer. I'm the head of the King's Chambers Engineering and Construction team. Thank you all very much for joining us for our construction update webinar. Just first of all, a little bit of housekeeping. As you'll all know by now, being familiar with Zoom, you will find on your screens a Q&A facility. If there are questions for any of our speakers, please put them on the Q&A button. I will look at them during the course of the seminar, and I think the best way is for me to put questions at the end. The only exception to that in terms of the end is that our first speaker, our judicial speaker, who we're delighted and honoured to have speak to us, Judge Davis, has indicated that he would be happy to take any questions at the end of his talk, and he's going to be speaking first. I'm just going to make a few introductions, and then obviously I'll come back if there are any questions for Judge Davis. But our first speaker is, of course, His Honour Judge Stephen Davis, who, as you will all know, is one of the permanent TCC judges in Manchester, and has presided over some very significant cases during his time, leading the local TCC to be very highly regarded amongst the TCC courts in the country. He is going to speak to us very appropriately on the Manchester TCC's continued support of dispute resolution in the Northwest and beyond. Our next speaker is Jonathan. Our next three speakers are from members of the King's team, and they are Jonathan Ward, Sarah Lawrenson, and Simon Arnold. Jonathan's going to speak on construction, defects and limitation, and in particular on a recent decision, Griffiths and Liberty Syndicate, which deals with limitation in defects insurance policies. Sarah is going to speak to us about indirect and consequential loss exclusion clauses, and the recent case of 2 Entertain Videos and Sony DABC. And finally, Simon is going to talk to us on adjudication, a practical perspective with an update. So thank you all for attending. I hope you enjoy the seminar. Judge Davis.
Yes, good morning, all of you. I'm very pleased to be able to speak to so many local practitioners and practitioners elsewhere in relation to the topic of the support which the Manchester TCC provides for dispute resolution in the Northwest and beyond. My only immediate regret is that I don't have a similar swanky background to those of the other speakers, and I'm afraid you'll have to do with whatever you can glean of my home study. I'm sure that what you'll be most interested in today is hearing what the Manchester TCC and indeed other courts both in Manchester and nationally are doing during the current COVID-19 related restrictions. And the short, simple, and I hope helpful answer is that within the limit of those restrictions, we are operating pretty much business as usual, so far as Manchester is concerned, and I'm talking particularly about the TCC, whereas Andrew has said, as well as me, there is another full-time TCC judge, Judge Stephen Eyre, Queen's Counsel, and a number of other judges who assist from time to time. There is a substantial business and property court section which deals with commercial and all manner of insolvency, company and real property type disputes. We are all working as normal, either by coming into the Civil Justice Centre when that is necessary, or working from home. As you would imagine, the current default position is that we hold hearings remotely, and like all of you, we have all developed through a rather steep learning curve a familiarity with holding hearings by Skype, by Teams, and by Zoom, as well as by telephone in the shorter hearings. We are, I hope, and I think, managing, although it's right to say that just because Judge Eyre and I sit in the technology court doesn't necessarily mean we are indeed experts in using technology rather than deciding disputes about technology. One thing that we have done is to improve the Manchester Business and Property Court website, where there is now, if you search it using search engines, a short biography of the judges who work in the business and property courts in Manchester, but more usefully, there is detailed guidance as to how we are dealing with hearings during the current restrictions. Useful guidance, I hope, is given as to how hearings are arranged and how the parties and how the court try to work together to ensure that hearings can be conducted efficiently and arranged and organised efficiently. Provisions for electronic trial bundles or hearing bundles for electronic written submissions, and to be supplemented, of course, by oral submissions and judgments over remote means. And the end result, I think, is that there is no delay or disadvantage to parties compared with the traditional oral hearings. And indeed, of course, there are potentially significant advantages in terms of avoiding unnecessary travel time. The only real practical difficulty is that because there are less staff coming into the building to answer the phones and so on, we do have to do more by email, and the more that parties can discuss, cooperate and agree practicalities in advance, the less the likelihood of difficulty or disruption caused by delay in communications. But one of the innovations that has been introduced is that when a hearing is arranged, the notice that comes out gives summary details of the procedure and the practicalities, the sort of thing I've already talked about. But it also ought to give an email contact address for the judge who is assigned to the hearing, although it is an anonymized Skype email address. And what that means is that if there are practical difficulties, for example, if there are connection problems or the like, you will be able to contact the judge doing the hearing directly by email to ensure that things get through and last-minute problems can be corrected without the need to have to wait for the staff to deal with, either pick up the phone or to deal with emails, which, as I say, given the current limitations on staff, has been a real benefit. And to give you a few examples, we have been continuing with the adjudication enforcement hearings process. I had one recently, I think a couple of weeks ago, where Simon Arnold was representing the successful claimant, and we have also been holding Part 8 hearings in connection with adjudication by video, as well as pretty much just about every other sort of interlocutory hearing in the TCC. We had a one-day application in a public procurement case recently, with one party being represented by a Queen's Counsel from King's Chambers, and Judge Eyre also had a contested application to adjourn a jurisdiction challenge in a very substantial group litigation case at the collapse of a dam in Brazil, where the claimants again are represented by a team of barristers from another Manchester Chambers. I just finished hearing evidence in a 4-week trial before the lockdown came into effect, but I was able to complete the trial by having 2 days of oral submissions over Zoom with leading junior counsel and solicitors from all over the UK, as well as a transcriber producing a real-time transcript. And that, it seemed to me, was just as effective as the traditional process. I would not be surprised if there were more remote hearings in appropriate cases, even after and if and when lockdown restrictions are lifted. And certainly we as TCC judges will be receptive to requests in appropriate cases for that to happen. The real question, I think, is trials. Until this week, there were no physical hearings in the Civil Justice Centre since the lockdown came into place. But as from this week, a number of courts have been opened which have been modified to allow traditional face-to-face trials to take place in safe conditions. And they can either be full traditional trials with everyone attending physically, counsel, parties, witnesses, and so on, or hybrid trials with the lawyers being present, but the witnesses attending remotely and the parties attending remotely as well. And in all these cases, I should say that unless proper grounds are shown, they will be open hearings in the sense that if any interested party or the press want to attend, they will be allowed to do so by video link in the same way. I am scheduled to start next week a 2-week trial where I will be sitting in court in Manchester, but where everyone else, including 2 counsel teams from King's Chambers, will be attending remotely with an IT service provider hosting a virtual trial bundle and a live transcription service at what appears, from what I have been told, to be a really quite reasonable cost, certainly reasonable compared to the more expensive system, such as was used in a trial which I had a couple of years ago, where Andrew Singer and Jonathan Ward were involved. And I shall be very interested to see how that works in practice. We held a trial run hearing yesterday. It all seemed to work extremely well, and it seems to provide a way in which witnesses who might not otherwise themselves be able to attend and who might not otherwise be able to navigate an electronic trial bundle can effectively be shown documents and answer questions whilst being in their own homes or other safe conditions. It is right to say that there are a limited number of these safe courts open, and there are also demands from other sectors within the Civil Justice Centre, particularly, of course, the family courts, where there are a number of urgent cases involving children, which may end up having to have precedence. But in an appropriate case, I am hopeful that we can have full-scale traditional hearings, but in most cases, unless there really is a compelling need, I suspect that the answer will be that as long as parties cooperate and the court is receptive, we will be having more and more remote trials, either in full or in part. There has also been flagged, although I haven't been involved in this, the possibility in appropriate cases of a third-party venue being provided by the parties or by the court service, in which a trial in the TCC or other business and property courts can be held, given, of course, that there are far fewer security and logistical difficulties in that sort of case. I've given in that brief run-through an illustration of the wide variety of cases which Manchester TCC currently hears. As we have said on many occasions, and more pertinently perhaps as the head of the Technology and Construction Court and the Chancellor at the head of the Business and Property Courts emphasised, there is no reason why any case of whatever size should not be heard in the North West, either by myself or Stephen Eyre as the 2 permanent specialist TCC senior circuit judges, or by a visiting full-time High Court judge, as is now going to happen with the Brazilian dam case, which has been said to be the largest environmental nuisance case ever brought in any UK court so far. Also, that's going from, as it were, the large scale. We're also trying to improve the quality of the service we can offer in smaller TCC cases, which are dealt with in the county court. Just before his retirement as head of the TCC nationally, Mr. Justice Fraser appointed one of our local Manchester district judges, Paul Manass, to sit as a specialist TCC judge in appropriate TCC county court cases, thus enhancing again the service which we can offer across the gamut of dispute cases. That's what I wanted to tell you about the way in which the Manchester TCC is currently operating. And since, as Andrew has said, I can't unfortunately stay till the end of the meeting, there is, I think, some time now for me to answer any questions, if there are any.
Thank you very much, Judge. I've had a very kind comment from Bill Barton at Barton Legal, offering to share tips because his firm handled a remote trial. And you can get hold of Bill at his email address, billbarton@bartonlegal.com. The other question I've had is whether there's going to be any priority given to trials, to administering trials at the earliest opportunity remotely or part remote to avoid a backlog, rather than doing, for example, waiting for particular parties who want to have a trial in person at a later date.
Yes, I think that the answer to that very good question is that it all depends on the particular circumstances. One of the, as you know, one of the big issues which arises is if you have a case where the credibility of one or more key witnesses is absolutely key. And for example, if there are going to be allegations of fraud or dishonesty put to that witness, there is a strong argument for saying that a traditional face-to-face trial is the fairest way of allowing both parties the opportunity to put their best case to the judge. But that said, the judges recognize that if every case where there was going to be significant cross-examination had to be adjourned until it could take place in a traditional way, the courts would be having nothing to do in terms of trials now and would be overwhelmed at a later stage. So I think we are taking, especially in the technology and construction courts, a reasonably rigorous approach and saying, well, in most cases in the TCC, it's unlikely that those sort of disputes or those sorts of issues are key, and therefore the presumption should be that we can and should hold trials remotely.
Thank you. I think we've just got time. One last question has just come in, which is, are the courts starting yet to see any COVID-19 related disputes, so force majeure or frustration type of cases, or have they not got there yet?
They haven't come across my desk yet, so the answer is no. I think one of the issues which is arising in the BPC more widely is as a result of the amendments in relation to insolvency, the ability of parties to enforce judgments, particularly perhaps adjudication enforcement judgments, may be affected by the provisions of the bill that's going through the Lords at the moment, but not force majeure at this stage for me anyway.
Thank you very much indeed, Judge. We are very fortunate, to have you join us for this webinar, but more than that, to have you and your colleagues, notably Judge Eyre, in the helm in the TCC in Manchester.
Thank you very much. I have very much enjoyed speaking to you, and I wish I could stay because I'm sure the remainder of the speeches are going to be excellent. Enjoy them all. Thank you.
Good morning.
Good morning.
Next speaker is Jonathan Ward.
Good morning, everybody. I'm going to try to share my PowerPoint presentation now, so if you just bear with me. Hopefully you can now see my PowerPoint. Andrew, can you see that? Yeah, okay. So as you can see, this is a talk about limitation periods applicable to construction disputes with a particular emphasis on defect claims. I'm often asked to advise on issues of limitation, and the purpose of the seminar is to consider how these issues should be approached and the issues that typically arise. In my experience, the best approach is firstly to identify the duties, the obligations and the causes of action that may arise in the circumstances that you're looking at. And then secondly, to identify when time begins to run in respect of each of those. So we'll look at some of the default positions in the more common type of claim and cause of action. And I'm also going to look at the fairly recent decision in Griffiths and Liberty Syndicate, which was actually a decision on a defects insurance policy of the type you often see in residential new build disputes. So depending on the scenario and issue, different types of duties and obligations may arise. So as I say, I'm mainly going to be looking at defect claims. And in this type of claim, if a claim is contemplated against a contractor, well, the contractor will usually owe the employer at the least a contractual duty, but a subcontractor probably won't owe the employer any contractual duty. There may be subcontractor warranties in favor of the employer, a funder or others. There may also be performance bonds. And if you have designers, architects, engineers involved, there may also be tortious duties and negligence, although the extent of these will often be controversial. If we're talking about residential buildings, there may be duties under the Defective Premises Act. There may also, as I say, be policies of defects insurance, such as in the Griffiths case that we're going to look at in a moment. The first point I'm going to look at is the position in negligence. In cases that come across my desk, it often seems to be assumed that even if a contract claim has run out of time, there may nevertheless be a claim in negligence, which is going to come to the rescue. But actually, at least so far as standard builders are concerned, that's often not the case. So what I'm going to look at to try to put it in some context is the case of Pirelli, which is a good starting point. And we're also going to look at the latent damage provisions, because those are often thought to assist. The Pirelli decision, it was a decision of the House of Lords. And the question that arose was whether time began to run in a negligence action when a defect first manifested, or when that defect first could have been discovered with reasonable diligence. The answer that the House of Lords came to was that time began to run immediately upon the coming into existence of the defect. And perhaps unsurprisingly, that was thought to be potentially unfair, hence the enactment of the Latent Damage Act in 1986. The Latent Damage Act, it works by inserting provisions into the Limitation Act 1980, and it's quite a technical piece of legislation. But for present purposes, I've set out some of the operative provisions, and you'll see that the way that it works is to define what's called a starting date, so that in theory there's no question when time begins to run, and time begins to run by reference to a date of knowledge rather than the coming into effect of coming into existence of defects. So it's quite clearly designed to address what was perceived as the potential unfairness arising from the decision in Pirelli. So in other words, if defects hadn't become reasonably obvious, time wouldn't begin to run on a negligence claim. So far, so good. But it's important to recognize in light of other developments in the law, what this legislation doesn't actually do. Firstly, it doesn't apply to claims in contract. So if you're looking at the Latent Damage Act, generally speaking, you're talking about claims in negligence. But perhaps most significantly, the Pirelli decision, that was decided before Murphy and Brentwood, another decision of the House of Lords, where it was decided that defects in a building were to be considered as economic loss, say to the extent that they'd already caused injury. So, in other words, if you're talking about a claim against a builder for defects, that is in effect a claim for economic loss, and a duty, as I'm sure you will be aware, generally isn't owed by a builder to avoid pure economic loss, absent some special assumption of responsibility. So we can see that in this slide. And if you want to delve into that point, the more recent decision of Robinson and P. Jones contractors is a good starting point. That went to the Court of Appeal and is a good discussion of the duties that arise in tort so far as builders are concerned. The short version is that they tend not to owe a duty in tort. The position, it may be different if we're talking about design and build contracts, but the effect of the decisions in Murphy and the cases that followed is that in relation to a negligence action against a builder for defects, the Latent Damage Act probably isn't going to be the get out of jail free card that you might be looking for. The next piece of legislation to look at briefly is the Defective Premises Act 1972. This actually, in contrast to the Latent Damage Act, this one can come in quite useful sometimes in defects claims. It applies to construction of a dwelling, so it's not a general application. It imposes a statutory duty to carry out the work properly so that when complete, the dwelling is fit for habitation. It applies to the creation of a new dwelling or the conversion of something into a dwelling. And importantly, time is reset if repair works are carried out to the original works. And this can have the effect of imposing fairly lengthy limitation periods in respect of certain items of defective work. Some time ago now, I had a case which involved the construction of a home, and it was actually constructed over about 20 years by a series of distinct and discrete contracts. Everything, we had a limitation trial, everything was out of time apart from some of the items under which were serious enough to fall under the Defective Premises Act. And we actually had some items of work which were done about 20 years earlier, which were ruled to be in time. So that's, if you're talking about a dwelling at least, this is always a good one to look at. And before we move on to the Griffiths decision, it's worth mentioning the position in contract and under the Contribution Act. Contract is fairly straightforward. It usually isn't subject to statutory intervention, save to the extent that the Defective Premises Act applies. Time generally begins to run at practical completion, or when the overall work ought to have been completed. So I suppose that's another way of saying that if you have a series of defects in a project, you're probably not going to be looking at a series of individual limitation periods, and the starting point is usually when was the building ordered to be completed. Remember that quite often construction contracts are executed by deed. So much the better if that's the case, because for our purposes, the limitation period is then 12 years rather than the 6 in contract. And also a trap for the unwary is that if you're thinking of a contribution claim, there's a special time limit under the Limitation Act, which is 2 years in respect of claims for contribution. So that's one obviously to be aware of. What I'm going to look at now is the Griffiths decision, which, as I say, concerned a policy of defects insurance. And as you may be aware, I think it's fair to say increasingly commonly, you will see if you are looking at a large development, a new build or conversion of an old building, the purchasers will often be offered a policy of defects insurance. And the one under discussion in this case is, as far as I can see, a fairly typical one. It provided for both a defects insurance period and what's called a structural insurance period. The defects insurance period ran for 2 years from 2008 to 2010, and the structural insurance period from 2010 to 2018. So overall, it provided for 10 years of cover, and that seems to be fairly typical. And this was a decision of His Honour Judge Pelling QC, and it was essentially a limitation trial. The defendant was applying to strike out or for summary judgment on the argument that the claim was out of time, not having been brought within 6 years from the accrual of the cause of action. So the judge began by setting out the policy wording. He sets it out quite extensively in the judgment. I've just put in a couple of extracts here. So we'll see that the policy provided that the underwriter will indemnify the policyholder during the defects insurance period and against the cost of repairing, replacing or rectifying any defect, and similar wording in respect of the structural insurance period in respect of the cost of complete or partial rebuilding or rectifying. So a point to note is that this was a summary judgment application, and the judge decided that he was able to resolve it on a summary basis and without a trial. And in doing so, he held that the only factual matrix underpinning the contract was the wording of the policy itself. So a trial wasn't necessary, and he could decide the matter essentially on the papers. So the question was, when did time begin to run? The claimants had notified the insurer more than 6 years before issuing the claim. So the simple question was, had time begun to run at more than 6 years before issue? So the claimants argued that the time of notification was not the trigger for liability under the policy. So time didn't begin to run upon the happening of the damage or the coming into existence of the defects, but instead at a later time, they said that time began to run when they incurred cost. So if we remember the way the policy was worded, it said that the indemnity was against the cost of repairs. So that led the claimants to contend that they were indemnified against the cost. Therefore, until they'd incurred a cost, there was nothing for the insurer to do, and time couldn't begin to run. They also pointed out that the insurer under the policy had the option of either paying for repairs or carrying out the repairs itself. The judge doesn't really elaborate on where this argument went, but presumably that the argument was that time couldn't begin to run until that choice had been made by the insurer. Unsurprisingly, the defendant disagreed. The defendant said that time began to run, not entirely clear from the judgment, but either when the insured loss was suffered or when the claim was rejected, and whether or not a repair had been undertaken. So the judge, in coming to his decision, he began his discussion by quoting from this decision in Callahan and Dominion Insurance from 1997, which is worth reading. There's a primary liability, that is to say to indemnify, and a secondary liability, that is to say to put the insured in his pre-loss position, either by paying a specific amount or it may be in some other manner. The fact that an insurer has an option as to the way in which he will put the insured into his pre-loss position does not mean that he is not liable to indemnify in one way or another. Immediately the loss occurs. So that began the judge's discussion of the arguments. He also relied on a much more recent decision of the Court of Appeal, which included Lord Justice Coulson and Lord Justice Jackson, formerly of the TCC, of course. And in that case, it was actually the insurer who had advanced the argument that the incurring of cost was the trigger for time beginning to run. The Court of Appeal dismissed that argument, noting that that would in effect defeat the purpose of such insurance. Because, for example, if the work was so extensive or expensive that the policyholder was simply unable to begin that work and incur the cost, the insurer would seem to avoid liability altogether. It also noted that the words indemnify against the cost would ignore the general principle that an insured can deal with the proceeds of a policy as they see fit. So that argument was rejected by the Court of Appeal in the Zurich case. And that Judge Pelling held was a reason to reject it in this case also. So far, not entirely promising for the claimants, but they did have a few more arguments. Firstly, they argued that because there was a minimum claim value in the policy, and since the value of the claim wouldn't be known until the work was done, the policy wording therefore suggested the claimant's construction, namely that time didn't begin to run until the work was carried out. The judge said that firstly that ignored the distinction drawn in the Dominion insurance case as between primary and secondary liability in relation to the indemnity. He said that it was merely a limitation of liability provision, and it ignored the insurer's option to either carry out the work or pay for work itself. So in other words, if the insurer did the work itself, presumably by appointing contractors, the cost may well vary to if it was sent out to a third party and carried out on behalf directly of the insured. The final argument, which I'll consider, was the continuing obligation argument. So in other words, the claimants argued that the obligation to indemnify was not a singular obligation which occurred once and for all at a certain time, but it was a continuing obligation. The example they gave was that if they requested the indemnity, which was rejected, they then went ahead and carried out the work and sought an indemnity in respect to the cost, the clock essentially would be reset. Unsurprisingly, perhaps, the judge rejected that argument. He said, for the same reason as given in relation to the earlier arguments, it ignored the primary and secondary liability distinction. But perhaps most interestingly in the way that the judge dealt with this argument was that if you look back over the judgment, although he dismisses the claimant's contention that time begins to run only on the incurring of the cost, until answering this question, he doesn't actually answer the question of when time does begin to run. And that's perhaps not entirely important, because if the claimants were wrong, then the claim was out of time. But we can see on the slide that the judge's conclusion on when time did begin to run was that once a claim has been made and rejected, time starts to run. And that's interesting because in the Callahan and Dominion case cited earlier, well, that's actually authority for the proposition that time begins to run not from the rejection of a claim or the avoidance of the policy, but from when the insured loss is suffered. So in this case, presumably when the defect first manifests. So I think the conclusion to be drawn from this decision is that, firstly, precisely when time begins to run is going to be a matter of the construction of the policy. Secondly, the overall purpose of this type of policy is going to be highly relevant to the construction that's adopted. But on the question of precisely when time begins to run, the starting point is probably going to be as set out in Callahan, namely when the defect manifests rather than when a claim is rejected. But in light of this, there's perhaps a bit of ambiguity. So that's what I've got to say on the subject of limitation and defects in insurance contracts. So I think we're holding over any questions to the end. So I'll hand back to Andrew at this point.
Thank you very much. And that's correct about the questions. Our next speaker is Sarah Lawrenson.
Hello, yes, I'm Sarah Lawrenson, another member of the construction team here. I would like to begin by saying that my email address appears on the first slide, which I'll show you shortly. Please do not be afraid. I think all of us here at King's Chambers have a very open approach. Whilst we have got the question and answer function, if anybody has any questions and wishes to email me later, either on at the topic of my talk or on anything else, please do feel free to email me or to pick up the phone and give me a call. You don't have to feel that a brief has to be promised in order to get some assistance. Another two small points, if I may, as well, following on from what His Honour Judge Davis said. Whilst King Chambers, we cover cases nationally and we have no hesitation when we can in travelling. Many of you will be familiar with the fact that we have 3 physical Chambers buildings in Manchester, Leeds and Birmingham. In relation to the Manchester TCC, many of you will be aware that the Leeds TCC has one full-time judge, His Honour Judge Rayside QC, who has recently moved to assist at the Rolls building. I had a 2-day hearing that was due to be heard by him during the lockdown, and he considered, perhaps quite rightly, that it wasn't an appropriate case to be heard remotely, and adjourned it just before he went down to London. As a result, the relisted date that we got for a 2-day hearing was not until June 2021. That would have created some real difficulties, certainly for my clients. As a result, those instructing me made an application both to Leeds and to Manchester to have the case transferred so that it can be heard at the Manchester TCC. That has been granted, and as a result, we've managed to get a date much sooner. In fact, it's going to be heard this summer. So for those of you that are concerned about the impacts that COVID is having on trial dates, I would echo and endorse what His Honour Judge Davis has said, that certainly Manchester, and this is not a criticism of Leeds, but certainly Manchester are doing everything they can to assist practitioners nationwide in trying to expedite cases as safely as possible. The question was asked again during His Honour Judge Davis's talk about force majeure. Actually, the main case that I'm going to talk to you about, 2 Entertain Video and Sony DADC, was handed down by Mrs. Justice O'Farrell on the 20th of May, and actually is a force majeure case. It considers that point. Whilst it doesn't relate to COVID, it actually dates back to the riots in 2011. It is the most recent TCC decision that I'm aware of on force majeure, or that considers force majeure. So I will touch on that at the end, albeit that the main part of my talk is going to be on indirect and consequential loss exclusion. So with that brief introduction, I will now hopefully share my screen so that you can see my PowerPoint. So as I've said, I'm going to talk to you today about indirect and consequential loss exclusion clauses. Of course, for those of us practicing in construction, it deals with both ends of the legal spectrum, in the sense that many of us will have to advise clients both on drafting their own contracts in relation to trying to exclude indirect and consequential loss, but also advising clients who are being asked to sign a contract that has such clauses. And of course, at the other end of the spectrum, we then have contracts that have been signed that appear to exclude indirect and consequential loss, and whether or not one can resist or not. There are 4 main cases that I'm going to deal with, to show what I certainly consider to be a move away from the traditional approach. So what is a consequential loss and an exclusion clause? Well, of course, it's a clause that seeks to limit liability for generally specific losses, special types of losses that have been identified in advance, i.e. at the drafting of the contract, and made known at the beginning of the contract, and whether or not, in fact, the contractual words will be considered important. Of course, as is standard, a well-drafted clause is always going to be crucial. I've put there at the second point that the claimant will only succeed if they can prove breach and causation, overcome the obstacles of remoteness, and show they've taken adequate steps to mitigate their loss. Whilst that may well be what we were taught at law school, I certainly consider that the law that is developed from Hadley and Baxendale in relation to consequential loss hasn't necessarily fitted within that more traditional contract law approach. So what is the traditional approach? Well, many of you will be very familiar with the case of Hadley and Baxendale and the two limbs of damages. The first limb, of course, is damages that arise naturally from the breach in the ordinary course of matters. And the second limb is damages that may reasonably be supposed to have been in the contemplation of both parties at the time that they made the contract, arising from the probable result of the breach. Now, whilst loss of profit and loss of management time are often thought perhaps to come within the second limb, damages in the contemplation of both parties, actually generally they are classed as a direct loss and come within the first limb. So the first case that I'm going to talk about in detail is the Crudes construction case, which was first instance but was upheld by the Court of Appeal. And there we had a contract which stated that we were not under any circumstance, or the contract stated not under any circumstances be liable for any consequential loss or damage caused or arising by reason of late supply. Now, actually, that appears to be a relatively straightforward and simple exclusion clause. However, it was held that the wasted costs of the workforce, plant and equipment arising purely as a result of the late supply, in this case it was masonry blocks, were not excluded by that very clearly worded clause. It was held, as I say, both at first instance and in the Court of Appeal, that in fact they came within Hadley and Baxendale's first limb. And therefore the traditional approach has not been to look at the wording of the contract, but to begin by defining whether or not it is limb 1 or limb 2. And if it is classed as being limb 1, regardless of what the parties have stated, the traditional approach has been to ignore that and to find that they are direct losses, and therefore they cannot be excluded by the drafting. Have we seen a move away from that traditional approach? Well, Transocean Drilling, the Court of Appeal again said it's questionable whether some of the cases, such as Crudes, would be decided in the same way today, when the courts are more willing to recognise that words take their meaning from the particular context, and that the same word or phrase may mean different things in different contracts, different documents. I would say that this echoes what Jonathan has just spoken about in relation to His Honour Judge Pelling's decision, which is more of a traditional contract approach than perhaps we have seen in relation to construction contracts, which is to look at what the parties intended. Of course, that has always been the approach taken in limb 2, but when it came to limb 1, there seemed to be less of, well, in fact, no reliance upon the contract itself, but merely that definition as to whether it was direct or not. It was highlighted that the court's task is not to reshape the contract, but is to look at the parties' intentions given the words they have used and the natural meaning. The second case that appeared again to show a move away from this traditional approach was Star Polaris, when the meaning of consequential loss and an exemption clause was considered, as I've just discussed, to be Hadley and Baxendale. However, it should be construed on its own wording in the context of the particular agreement as a whole. And in this case, the shipbuilder had expressly agreed to repair or pay for physical damage and some other identified consequent expenses. Here, and quite unusually in this contract, the liability provisions of the contract provided a complete code for the damages in total. And the court held that by excluding liability for consequential or special losses, damages and expenses, the parties had intended to exclude all financial losses consequent on physical damage, regardless of whether or not they would traditionally have come within Limb 1 or Limb 2. And so that brings us on to the To Entertain video case. This has had, as I say, this arose from the riots in 2011 and a fire that was caused at Sony's warehouse as a result of those. As a result of that fire. Now, many of you will be familiar with the fact that To Entertain Video is the BBC's commercial arm. And the BBC, or To Entertain, 2E, had around £40 million worth of stock in the warehouse that was destroyed by the fire. The initial claim that was brought was actually brought by Sony's insurance company under the Riot Damages Act, and therefore 2E were compensated for the £40 million worth of stock that they had. But the issue then arose in relation to 2E's loss of profit, other business interruption losses, etc., arising from the fire. And it was considered by both parties that that was a failure to supply the logistics services under the contract, rather than as a result of the loss of the stock itself. And the relevant exclusion clause here, I've set out there. I've underlined the second part, which you'll see why in a few moments. But it said, neither party shall be liable under this agreement in connection with the supply of or failure to supply the logistics services for any indirect or consequential loss or damage, including to the extent only that such are indirect or consequential loss or damage only, but not limited to loss of profit, loss of sale, loss of revenue, damage to reputation, loss or waste of management or staff time, or interruption of business. Now, quite what that means and was supposed to mean is, of course, not entirely clear. It is clearly a not well-drafted exclusion clause, and I fully suspect was as a result of negotiations rather than being any form of standard wording. And the Court of Appeal certainly said that the ordinary and natural meaning of this provision was what the court needed to look at, but that it was very unhappily drafted, particularly in relation to that second section that I have underlined. To the extent only that such losses are indirect or consequential loss or damage only, but not limited to, and then the matters that are listed there. Sony relied upon another clause as well, which provided that their liability for any loss or damage shall not exceed their manufacturing replacement cost. This comes back to the point that had been made in Star Polaris that I've recently spoken to you about, in which there was a full code for damages. And so Sony tried to argue that, as had happened in Star Polaris, there was a full exclusion there in the alternative to their primary case, that all of these matters that 2E were claiming came within the exclusion clause, but secondly, or in the alternative, that there was a full code there, and therefore the manufacturing replacement cost had been dealt with by the earlier case, and therefore, notwithstanding that this was a logistical service case, that the relief had already been provided. The court disagreed, and this is the decision of Mrs. Justice O'Farrell. She said she held that, unlike in Star Polaris, the clause did not attempt to define Sony's liability for all of the breaches, but was only concerned with compensation for the loss or damage to the goods, i.e. what had been dealt with by Sony's insurers, and therefore could not preclude a claim for loss of profits. The court went on to say that there was no definition of indirect or consequential loss in the contract, as there was in the Transocean case, that would suggest a wider meaning than the second limb. I'm not sure I entirely agree with that, given if we go back again to the exclusion clause, whilst it says it's not limited to, there is certainly a lot of detail there in relation to what the parties had considered indirect or consequential loss or damage to be. But there we are. The court did agree with Sony that any general understanding of the meaning of indirect or consequential loss must not override the true construction of the clause when read in the context against the other provisions in the contract and the factual matrix. That, of course, is the main move away from Hadley and Baxendale again, rather than the starting point being to define whether or not it comes within the second limb. Mrs. Justice O'Farrell was making it clear in my view that the starting point has to be the contract, the parties that the court, that the words and the normal meaning of those, rather than simply this old school approach of does it come within what we would traditionally understand simply to be indirect and consequential losses. However, the court did not fully agree with Sony and held, as under Hadley and Baxendale, that in fact when one looked at the true wording of the contract, these losses flowed naturally and directly from the fire, and therefore Sony's breach in failing to provide the logistical services. It's not a bottling. I'm not going to accept, there have been some commentators who've suggested that. I don't agree with that. In my view, Mrs. Justice O'Farrell has been very clear to define how the court would approach cases coming within Limb 2, but in this case held that in fact no consideration was required because they simply did not fall within indirect losses. The losses that 2E were seeking came within the logistical, came within a direct breach of the logistical services. Finally, as I said, I would deal with, there was a force majeure clause, and perhaps not surprisingly, Sony argued that the riot could not have been predicted, and therefore the force majeure clause, which was in standard wording, should kick in. And certainly in relation to the logistical support, it couldn't do it because the building was not there for it to provide it, the goods were not there for it to provide its logistical circumstances, and that it was circumstances beyond its reasonable control. At the beginning of the decision by Mrs. Justice O'Farrell, she had to make some extensive findings of fact in relation to what Sony could or couldn't have done in relation to planning for riots, not with knowledge that a riot was going to happen, but simply generally in relation to that. For me, I would certainly say that pandemics, whilst we have not suffered one before, certainly in the UK to the extent that we are now suffering, are certainly things that for the last 5-10 years we have been warned of. And therefore, I do think that parallels can be drawn in relation to pandemic planning, as there was here in relation to riot planning. And in this case, Sony had subcontracted out and had taken advice in relation to the impact that a riot may have and fires may have. And they argued that in taking specialist advice in the way that they had, they were absolved of any liability and in effect had done everything that they could, anything that was in their reasonable control. Mrs. Justice O'Farrell disagreed with that and found that in fact it was not reasonable in these circumstances to rely upon their experts, to some extent finding that they had chosen the wrong experts to assist them, and therefore found that that although the riot was unprecedented and unforeseen, that in fact Sony could not avoid liability in those cases. So again, if you are, any of you, concerned about force majeure, it's certainly worth having a look at this case. Although, as I said right at the very beginning, this is more a case, in my view, on indirect and consequential losses. And with that, I believe I hand over to Simon. I'll just stop sharing my screen in case he needs it.
Good morning, everybody. Hopefully you can hear me. Yeah, I won't be showing any slides this morning, but like Sarah said, we're fairly informal. So if anybody wants to see a copy of my speaking notes, please do either telephone or email, and I'll happily share those with everybody. So the topic I'm going to address is adjudication, a practical perspective. My subheading for this is turnover is vanity, profit is sanity, and cash is king. So rather hackneyed and well-used saying, but in this unprecedented time, I think the saying is particularly pertinent. So as we all know, the lifeblood of any business is cash, and this is particularly apposite for any business operating in the construction sector. Often payment is made monthly in arrears, the contractor having purchased goods and materials in advance, and generally having paid its workforce on a weekly basis. The contractual machinery then grinds into action with the regime payment applications, notices and the like. This is when disputes are likely to arise. What's a fair valuation of the works? Was so-and-so variation? If so, on what basis should it be measured and valued? And does that entitle the contractor to an extension of time? For many disputes, adjudication will quite rightly be the first port of call, and that's what I intend to focus on in this talk, and in particular, the court's approach to the enforcement of the adjudicator's award. So firstly, what I'll look at is the court's general approach to adjudication. How does one go about enforcing that award, and what are the likely timeframes, and has the current pandemic affected those strains, given the obvious strains that is imposed on the court's limited resources? And you've just heard from His Honour Judge Stephen Davis that so far the Manchester TCC has been able to comply with the indicative timeframes given in the TCC guide. And certainly my recent experience is for issuing an application for summary enforcement on adjudicator's award post-COVID-19, it was dealt with very quickly, and we had a final hearing within about 4 weeks of the issue of the papers. So adjudication has a number of well-known advantages. It's usually a quick process. A decision is generally required within 28 days of receipt of the referral notice, subject to any extensions of time so that the parties may agree. It can be cheap. There's no requirement to use lawyers, and most disputes can be incurred without the need for lawyers, particularly when the disputes centre on payment applications. And subject to a very few and on the whole limited exceptions, the award is enforceable through the courts by way of summary judgment. And the award is temporarily binding on the parties, subject to any final determination, whether through legal or arbitral proceedings. A party may choose not to comply with an adjudicated decision and challenge it once the successful party commences enforcement proceedings. However, challenges to adjudicators' decisions rarely succeed because of the court's robust approach to enforcement. The court's view is that because the decision does not finally determine the party's rights, it should be enforced, even if there is an error of fact or law. And there's two very recent decisions of the TCC which illustrate this robust approach. The first is a decision from the 4th of May 2020 from Mr. Justice Peter Fraser, the former head of the TCC, in J&J Hopkins Limited and Trant Engineering. That case concerns a subcontractor's entitlement to payment in respect of interim application 26, in respect to which neither pay less notice nor payment notice had been served. So essentially this was a smash and grab adjudication. The contractor resisted summary judgment on the basis that the claimant was no longer entitled to the sum awarded in that adjudication, because application 26 had been superseded by subsequent interim payment certificates, which had corrected the sum payable under the subcontract. This is sometimes referred to as the correction principle. And that to order payment in such circumstances, i.e. where that amount had been corrected, would be manifestly unjust or would undermine the correction principle. So the remarks of the judge in that case, particularly salient, and I'll set out what he said. He said, quote, "There are only very limited grounds upon which adjudicated decisions will not be enforced by means of summary judgment. The very first case on enforcement was a decision of Dyson J in a case called Macob Civil Engineering and Morrison Construction, in which it was made clear that an adjudicator's decision will be enforced by summary judgment, regardless of errors of law or errors of fact contained within it, or the merits of the underlying dispute resolved by the adjudicator. The starting point is that if the adjudicator has decided the issues referred to him or her, whether he or she is right or wrong, in fact or in law, as long as they have acted broadly in accordance with the rules of natural justice, that decision will be enforced by summary judgment. That is a principle that's been around for, as of today, over 20 years. So that is pretty clear. That statement of general principles subject to very narrow exceptions. The first is if there's been admitted error, and the second if there's an issue regarding the timing or categorization of certain documents such as payment notice or a pay less notice. And again, recently, in 29th of April 2020, that latter point was also addressed by Mr. Justice Fraser, and it is in a case of J. Tomlinson and Balfour Beatty Group Limited. Here the parties dispute related again to the claimant subcontractor's interim application number 30, which again the adjudicator had decided was a default payment notice was due and payable, awarding the subcontractor around £1.24 million. Again, this was another smash and grab adjudication. In the enforcement proceedings that followed, the defendant contractor argued that interim application 30 was invalid and relied upon terms in the subcontract. It was a technical argument suggesting that the interim application was served on the wrong day and therefore was premature, and that it was delivered by hand rather than by post, which is what an appendix to the contract requires. It was argued that this meant the document could not be a default payment notice, and that was therefore contrary to the findings of the adjudicator. Those arguments were both rejected by the judge. He said the wording in the appendix was not sufficient to support the contractor's arguments, and the wording in the appendix was not mandatory, and it did not change the nature of the interim application. He said the subcontract had to be construed as a whole, and in doing so it was clear that service of interim application 30 by hand was valid service. So as I stated at the beginning to this talk, the enforcement of an adjudicator's decision, so challenging enforcement of an adjudicator's decision is not easy. What is clear, in my view, from these two very recent cases is that irrespective of the attractiveness or otherwise of the claimant's position, and irrespective of any errors of fact or law, that decision will be enforced. Practically, this will be of comfort to those of your clients who wish to commence an adjudication process or have the benefit of an adjudicator's award, because they will know that subject to some very limited exceptions, that award will be enforced. And in terms of enforcing the adjudicator's award, the TCC has developed a specialist procedure which is set out in some detail in section 9 of the TCC guide. In summary, the enforcing party issues a claim form and particulars of claim, which are fairly straightforward documents and can be drafted fairly swiftly. At the same time, an application notice is issued, setting out the direction sought, usually with a request to bridge time for service at the non-service form, and various other procedural steps, coupled with an application for summary judgment under Part 24 with the usual supporting witness statements. The TCC guide suggests that the judge should deal with this within 3 days of receipt by the court, and that is dealt with on paper. And the draft standard directions are contained as Appendix F to the TCC guide. The TCC guide also indicates that the final enforcement hearing should be listed within 28 days of the directions being made. And it's reassuring to hear, and certainly direct experience has borne out, that notwithstanding the COVID-19 issues, certainly the TCC in Manchester is still managing to comply with those requirements and to list remote hearings to deal with summary enforcement actions. So returning to my theme regarding non-compliance with adjudicator's award and converting that into cash, even in these circumstances, within 31 days of issuing its application, in theory, the claimant should have had its enforcement hearing, and assuming all goes to plan, a High Court judgment which it can enforce in the usual manner. It might be worthwhile just spending a moment or two looking at the limited exceptions where the court may refuse to enforce a summary judgment, may refuse to enter summary judgment. So broadly, the exceptions can be categorised in two ways, where the adjudicator has acted without or in excess of his jurisdiction, or where he or she has acted in breach of the requirements of natural justice. In terms of jurisdiction, a helpful case which identified the different types of jurisdictional disputes is Edmund Nuttall and R.G. Carter case back in 2002, decision of His Honour Judge Thornton QC. He identified two broad types of jurisdictional disputes. One he termed an internal jurisdictional dispute. So that includes issues about the terms and conditions of the contract and whether the parties have complied with the payment provisions set out in the Act. In general, the court will enforce an adjudicated decision on internal jurisdictional disputes, even if the adjudicator has erred in fact, law, or procedure. The second broad type of jurisdictional dispute is what we all know as a threshold jurisdictional dispute. Those are matters which go to, quote, questions relating to the ability to set in train an adjudication process at all. Threshold disputes include questions as to whether there was a construction contract and whether the dispute has crystallised, and in relation to contracts before 1st of October 2011, whether such contracts were in writing. In terms of threshold jurisdictional disputes, if the adjudicator wrongly decides that he has jurisdiction, the courts will not enforce his decision. So by way of quick example as to cases where the courts have found that the adjudicator lacked jurisdiction include cases where there was no concluded contract. An example of this is AT Stannard Limited and Tibet from 2014, where the responding party unsuccessfully argued that there'd been an innovation, which meant the parties in the adjudication were not the same parties as the parties to the contract. Questions which go to whether the contract was a construction contract for the purposes of the Construction Act, whether the contract was in writing or evidenced in writing. As I said, this only applies to contracts entered into before 1st of October 2011. So challenges on this point now are fairly rare. Non-compliance with Section 108 of the Act. These are instances where the contractual adjudication procedure does not comply with the requirements of the Construction Act. Situations where the adjudicator's appointment was invalid. For example, the referring party may not have complied with the requirements of the Act or the scheme, or failed to comply with the provisions within the contract. An example of this is Ecovision Systems Limited and Vinci from 2015, whereas Honourable Judge Havelock Allen QC, sitting in Bristol, held that an adjudicator lacked jurisdiction because he was not properly appointed and he followed the wrong set of adjudication rules. Situation where no disputes have crystallised. Situations where the dispute may have been dealt with in a previous adjudication. If the dispute has been referred to a previous adjudication and the decision has been made in that previous jurisdiction, that will prevent determination of that dispute in a subsequent adjudication. Or the dispute is the same or substantially the same as a dispute already decided by an adjudicator. That's a question of facts. An issue was considered by Lord Justice Dyson in Quickfield Limited and Vascroft Contractors. Or the adjudicators determined a dispute that was not referred. An example of this is McAlpine PPS Pipeline System Joint Ventures and Transco from 2004. In that case, the judge, His Honour Judge Tourmalin, refused to enforce an adjudicator's decision because the adjudicator had decided what he regarded as the real dispute, rather than the dispute that the parties had in fact referred to him. In that decision, the court concluded that the adjudicator had no jurisdiction to go beyond that was referred to him in the notice. Situations where the adjudicator has failed to reach his decision within the required time frame, or the adjudicator has imposed preconditions to the publication of his decisions. For example, situations where the adjudicator has required prepayment of his fees as a condition to release of his decision. Now that's generally dealt with in the adjudicator's terms or conditions, or the particular rules which apply to the adjudication process. The second broad category where the courts will refuse to enforce the adjudicator's decision is where there's been a breach of natural justice. The question then is, what is meant by natural justice in this sense? Well, natural justice requires that every party has the right to a fair hearing and the right to be heard by an impartial tribunal. So in those circumstances, an adjudicator's breach the rules of natural justice may include situations where he or she has failed to act impartially as between the parties, where there's been apparent bias or actual bias, or there's been some form of procedural irregularity. In terms of impartiality, that is a requirement of both the Act and the scheme for the adjudicator to act with impartiality. Whereas in contrast to arbitrators, the adjudicator has no statutory duty to act fairly or to adopt procedures ensuring a fair means of resolving the disputes. In Carillion Construction and Devonport Dockyards, a Court of Appeal decision from 2015, the Court of Appeal said that an adjudicator who acted in serious breach of the rules of natural justice would not have his decision enforced. Also, quite presently in that case, Lord Justice Chadwick, and this ties back to the theme regarding converting work done and decisions made into cash, said this in relation to the task of the adjudicator, in quotes, "The task of the adjudicator is to find an interim solution which meets the needs of the case. Parliament may be taken to recognise that, in the absence of an interim solution, the contractor or subcontractor or his subcontractors will be driven into insolvency through a wrongful withholding of payments properly due. The statutory scheme provides a means of meeting the legitimate cash flow requirements of contractors and their subcontractors. The need to have the right answer has been subordinated to the need to have an answer quickly. The scheme was not enacted in order to provide definitive answers to complex questions." So certainly in the present climate, with the uncertainty we have, those words from Lord Justice Chadwick nearly 15 years ago, I think, ring particularly true nowadays. And certainly within the context I've outlined of the court's approach to adjudication, the ability for a successful party to enforce the award is particularly apt now. In terms of breach of the rules of natural justice and impartiality, I'll just give a few examples as to situations where an adjudicator has been found to act impartially, where there's been separate communications with the parties. For example, that's Discane Project Services Limited and Oppo Crime. Situations where the adjudicators failed to consult with the parties, which include where the adjudicators received communication from the party but failed to mention it to another. The adjudicator decided on a particular approach to the dispute, but have not given the parties a chance to consider that approach or make submissions on it. Situations where the adjudicators relied on a report commissioned from a third party. Situations where the adjudicators obtained legal advice from a barrister, however informal that may have been. and circumstances where the adjudicator has formed a preliminary view on the dispute and again has failed to inform the parties regarding that, or situations where the adjudicator has failed to exercise a discretion or to consider whether to exercise a discretion, and where the adjudicator has used his own knowledge and experience but has not given the parties an opportunity to comment on that. And in certain circumstances, that too may amount to the breach of the rules of natural justice. So finally, in relation to that, if the adjudicator takes an erroneously restrictive view of their jurisdiction, for example, failing to consider part of the responding party's defence on the basis that it fell outside the scope of the dispute referred to him. So with that quick canter through the court's approach to adjudication, that the points I wanted to draw out are these, is that subject to the very limited exceptions, and these are exceptions which have been developed over 20 odd years of case law, the adjudicator's award will be enforced. It matters not whether the adjudicator has made errors of fact or law in his decision, provided he's dealt with the dispute referred to him. The TCC has developed an expedient way of dealing with enforcement on the adjudicator's award. And irrespective of the current pandemic, the court is still in a position to be able to resolve those quickly, and this remote hearings to deal with the parties' needs. So if there's any questions, I think the approach is to email them to Andrew. On that basis, I'll hand back to Andrew for me.
Thank you very much. Thank you, Simon. Thanks to all our speakers. Jonathan Ward has, in the best traditions of the law, had to go and have a hearing. So he apologises for having to leave slightly early. I have not received any questions by the Q&A, but as all the speakers have made clear, and it applies to me too, if there are questions which want answering, we're all very receptive to email communication.